Yes, Mr. Rowley.
Yes, please, my lord and my lady. The respondent respectfully submits that the Court of Appeal decisions represents a careful and just resolution of the dispute, recognizing the contractual and factual reality that the works in question with genuine contractual variations were validly authorized by the appellant's own appointed engineer, and the respondent is entitled to payment for that. The appellant now seeks to rely on the rigid contractual terms to avoid paying for works it benefited from, and through its engineer expressly requested. The respondent recognizes the appellate court must be cautious before interfering in findings of fact. The respondent submits that the Court of Appeal intervention in this instance was fully justified in accordance with the principles as set out in Beacon Insurance Company Limited and Mirage Bookstores Limited, which was relied upon in the respondent's written case. The trial judge's errors, which the Court of Appeal correctly found to justify intervention, included: the trial judge failed to appreciate that it was the appellant's own engineer, Mr. Paul, who approved the variations, thereby undermining the finding that the respondent chose to deviate from the contract. The trial judge failed to properly examine the consistent, detailed accounts of the respondent's witnesses, corroborated by the appellant's own engineer, and weigh them against the unrefuted documentary evidence. The conclusion the respondent had not proven his case was plainly unreasonable, given that overwhelming first-hand evidence that the works were instructed, carried out in the authority's interest pursuant to its authorized engineer determinations instructions, in the interest of the project and without any refuting evidence from the appellant as to same. My lords and my lady, respectfully, before addressing the main issues in this appeal, I wish to anchor the court on the factual and contractual context in which the project unfolded, which is established on the record. My learned senior friend on the other side did touch upon the fact that the appellant is a statutory authority with a mandate to manage and provide for the water sewage sector in Trinidad and Tobago. It is true. The respondent submits that this appeal must be viewed through the lens of the facts as they unfold on site, not a purely abstract contractual reading, as where the judge appears to have acted in error, and where it appears the appellant is seeking this court to follow. The contract in issue was for the execution of civil and infrastructural works under a FIDIC-based form. The project required the rehabilitation and construction of water infrastructure within a defined scope, namely the installation of transmission pipelines within a geographical area of Trinidad, being the area of Rio Claro and Mayaro. The appellant places heavy reliance on the proposition that the party's contract was a lump sum fixed price contract, and that the respondent was expected to have satisfied itself ahead of time about the design and requirements for completion, and the fixed price was sufficient. The respondent in alternative submits that the printed record reflects that at the time of contracting, in particular, when the respondent submitted its tender, neither the appellant nor the respondent were in a position to properly appreciate the full scope of the works. And indeed, both parties proceeded on the shared understanding that the works were to commence quickly to fill the appellant's requirements. This is evinced by the factual matrix that works commenced before the written contract was executed. Is against a factual background that the variations later identified and approved by the appellant's engineer must be viewed.
But does this have any legal significance? This point about works being commenced before the contract was executed.
So what?
Does it matter legally?
Yes, please. This is in reference to the fact that heavy reliance is being placed on the respondent is fixed with at the time of contracting and the time of issuing its tender. It would have fully known the full scope. Therefore, what is being presumed or being asserted as variations are not variations, but were in fact covered. And that's an important element that is a issue that must be resolved in this claim.
But
The fact that if
it
it
was
was
only
not,
a few days. They only started work a few days, wasn't it? 7 or 8 days before the contract was signed in May.
yes, please.
So
Yeah,
it was a
yes,
few
please, Ma'am.
days, but they knew the terms of the contract because that was included in the tender information, wasn't it?
Yes, please, my lady.
And they chose to start before they signed the contract. That's your client's choice. At their risk.
I see where my lords and my lady are leading to, however, is in relation to whether or not the fixed scope was effective at the material time of contracting and at commencement of the work, which is relevant to the fact of whether those works were in fact, the parties recognized that there was a complete scope of works at the time of engagement and commencing. If the parties...
But it was plain to your client that they were responsible for the design, the location of the pipeline, all these things. If they started a few days before they signed the contract, that doesn't make the slightest bit of difference to that, does it?
I agree with my lord, and the submission that is going to be made and which we are saying is fleshed out on the record is the fact that while this contract parades itself as a design bill and a lump sum contract, the reality was far from it. And this is why there are courts to determine while parties may contract with each other and say certain things on documents. It was fleshed out before the Court of Appeal as well. And I think it may have been why the learned trial judge may have saw it fit to speak about implied terms in the contract, but that she may have acted in error in that instance. However, the reality is that while the parties may have been, it may have been envisioned that the contract was to be taken as a lump sum or design bill, it was, the parties did not really enter into such a contract. And that is why the variations as how they came to be and how it was treated is far different from what the parties, well, not the parties.
Are you saying that the parties didn't enter into the contract on the terms that we've got in front of us?
What I'm saying, respectfully, please, my lord and my lady, is that the parties entered into a contract with certain terms, and it is on the basis, as well as what the Court of Appeal will have recognized, that the contractual terms allow for flexibility for the fact that the parties recognize that whilst the contract did provide for terms, they did see it fit to discuss and agree with themselves in terms of as to the carrying out of the work, that the interests of the work took precedence. Therefore, the formalities and requirements of the contract were waived. And that is where the estoppel and unfair determination came out from the Court of Appeal, please, my lord.
Well, the first problem with the waiver argument is you never made that argument in your pleading or at the trial, did you?
And it is part of my written submission, how we wish to treat with that. But it will be part of my submission coming forward, but to address it at this instance and then exploring it in a little more detail at a later point, we are saying it was set out and the parameters of the case, while it may not be have specifically pleaded, it did arise on the trial. We are saying the cross-examination took the context within which that issue.
You can't raise an issue just by asking a question in cross-examination, Mr. Ali. You've probably been practicing long enough to know that by now.
Yes, and that's why we relied on the authority of Charmaine Bernard. It's referenced in our written, that where parties set out, whilst it may not, the principle behind the pleading is not to catch a party off guard. It ought to be touched upon. It's our submission that it was touched upon. It was a live issue at trial. That is why the
touched upon in the pleading, do you say, or you're saying it's touched upon at the trial?
I'm saying it's touched upon, even though it may be not specifically pleaded in terms of...
Because I couldn't even find it in the written submissions at the trial. In your client's written submissions don't seem to have any reference to waiver or estoppel anywhere in them.
Not at the trial stage, please, my lord. It only finds itself at the appeal stage.
Well, it's a bit too late by then.
But we're respectfully saying it was part of, if the court were to look at the references to the pleading, it would flesh out the equitable principles that you instructed me, your agent instructed me to carry out works. I acted on those instructions, carried it out, and therefore, on reliance of it, I incurred the detriment. Those are the principles with it. If an equity had to be pleaded, those were the same pleas that would have had to find themselves in the pleadings. And it is, when you look at the pleadings, you would identify respectfully that that is what is, in fact, made out on the pleadings. But where I wish to...
Sorry, just to be clear, as I understand, waiver is not specifically pleaded and is not in the written submissions at trial. That's correct?
Correct, please, my lord.
Okay, thank you.
Yes. So why I wish to spend some time with just setting the background is because it's very important for the fact of how the parties treated with the contract, how the parties, in terms of wavering and not complying with the procedural requirements, it sets from the genesis of how the contract came to be and how the contract was treated, and up to the termination of the contract, please, my lord and my lady. So if I may be given some liberty to just mention it for probably 5 minutes. The respondent's bill of quantities was submitted in October 2006. The site minutes of the 22nd September 2006, and if the court wishes to have a reference, it's at page 377 to 380, are telling that the visits were merely for familiarization with the pipeline route, not for detailed investigation, materials, or ground conditions. Even the pre-minute meetings of the 3rd of April 2007, only 6 weeks before execution, record that, and that's at page 384 to 385, this is a design build contract with preliminary designs have been provided. The contractor is required to complete final designs quickly so that any additional material can be ordered. Site visits and confirmation works to be arranged. That is 3rd of April 2007. These words alone confirm the design and material requirements were not yet finalized, and the parties were working under pressure of time and not under settled technical conditions. Based on the consistent and unchallenged evidence of respondent, the works began on the 15th of May 2007. However, as I indicated, the contract was only entered and the date was 23rd of May 2007, 8 days after the works had already commenced. So at the point in time, it's the respondent's submission that the respondent and the appellant were operating the instructions of urgency and not on the finalized or fully scoped design build contract.
But during those months between October, whenever the process started, you said, and April or May 2007, your clients had plenty of opportunity to go and inspect the site of the proposed works and carry out any tests they wanted to on the ground to see what the ground conditions were.
But, and one of the arguments will be, in terms of the variation, that's very relevant to the variation. We are saying even if that had transpired, and I understood this board to be referencing that the genesis of the variations stemmed from the cutting of the asphalt. We are saying, even if they had done a site inspection, they would have done the site inspection and the testing or whatever was required to know what was required to fulfill the contract based on the initial instructions or the parameters of the contract. And we are saying the parameters was to...
Well, the parameters were that your client had to prepare a design and work out how much it was going to cost to execute it and submit a lump sum that would enable it to be achieved.
Well, look, my lord, what the respondent will respectfully submit as to the design, where the pipe was to be laid, was not for the respondent to determine.
Where do we find your client's design?
Yes.
In the documents? Where do we find the design?
Yeah, respectfully, that is not part of the record, please, my lord.
Well,
I would like to take, my lord, in terms of where
My understanding on the facts was that the change of route, as it were, was only that instead of going along the verge next to the highway, it actually went under the highway. You're not talking about some change of route different from that, are you?
No, please, my lady. And what I will indicate, the condition of where someone prepares, where a road exists, it's a factual and practical issue. That where a road exists to where a verge exists, where the pipeline, and we're saying the design, the layout was identified by the appellant, not in terms of the specifications of how to build it. Agreed. And we are even saying that that did not come to full fruition in terms of the complete design build. What would be fleshed out in the claimant's claim, and which I intend to address the court on at a later point, is it in reality the contract turned out to be operating, which the parties accepted, as opposed to design build, it was as built, because of the nature of the urgency and the manner in which the contract to get the works done. What the court will see from the printed record, the testimony of the witnesses, inclusive of Colin Nims, is that was to get the work done. And we are saying when the court looks at all that transpired in the factual record, everything was driven by to get this works done. And it ought to be appreciated that this is, and my learned friend on the other side made huge reference in the fact that it's a public authority, based on the fact that as well the respondent will be fully cognizant of that fact and would work with the appellant to achieve those aims. And in those contexts, which I will address the court on coming down later, is why we are saying that it's very important that while this contract premises itself on design build full lump sum, the full scope and extent was not known. That gives rise to why variations occurred. And to take, I just wish to mention the fact of if the court wishes to have some reference as to it was not a determination of the respondent as where to lay the pipe, where the pipes were to be laid at page 553 of the record, excavation backfilling for pipes and appurtenances. The mains are to be laid to the roots and grades shown on the drawings. These conditions of the contract would have been drawn up prior to execution. It would have been part of the initial, I hope I'm correct. Let me just ensure that I'm not. But in terms of the designs, we are saying that was initiated prior to and at the time of tendering. It was the appellant who would have determined that. Therefore, we are saying testing and analysis or site inspection as to where these pipelines would have been determined. Even if the respondent were to have carried out, it would have been a totally different condition to where a road is, where you have to cut asphalt, which would have been prepared for the purpose for which a road is to be used. So that is where you would encounter rock, certain materials necessary to make a road worthy for that use.
But I'm sorry to interrupt, but the bills of quantities and the specifications are full of references to cutting through the asphalt and cutting through the subbase and the base and reinstating the subbase and the base. I mean, there are about a dozen references in all that I've found. So I mean, even the passage you've just taken us to, 2 paragraphs further on, it expressly envisages cutting through asphalt.
Well, look, when we look at the bill of quantities, and they're mirrored at each other. So let's take for package 1. In the bill of quantities, bill 2, mainstay and savings at page 665. When we look at item 1.1, these are the item 1 what was the contract, what was envisioned in the contract. It speaks to excavate, lay backfill, and DI pipe, DN 500 millimeters. This is what was envisioned by the contract. Excavating is that the respondent submission, excavating and cutting are 2 different things. And when we look at the preamble to
Well, then look at 2 and 3 on the same page. Importing fill, road reinstatement, all priced as part of the lump sum.
And we are saying that that is a contingency provision. It was not that the contract, it did happen, and my friend alluded to it. At some point in time, there may be instances where it may envision that you do have to cut in front, but it was not the primary, it was not the provision of the contract that it is to cut asphalt. It was in the verge. These are contingencies for the basis that you may come across some areas where you have to cut into the asphalt. And to assist my lord and my lady a little further, in the preamble to the bill of, to the preamble to the contract, at page 288, P19, it says excavating.
288.
288 of the, yes, 288, it speaks excavating in any material other than rock, concrete, reinforced concrete, asphalt, or bituminous macadam, including removal of topsoil from trench line stockpiling, excavated material, timbering, drawing, and so it specifically says not excavating other than asphalt.
But that's because it's covered by the previous item in the bill.
It's the respondent's respectful submission that that is not, there's a contingency for in the instance that there may be, but that the premise of the contract and is that it was to be laid in the verge. That's why excavating is on the main area. You are providing for excavating, not cutting in asphalt.
The reference to rock, concrete, reinforced concrete, asphalt, and so on in P19 comes from the reference at P18.
Yes, please.
So you have to read those two together.
I'm guided, but we're still saying when the contract is looked at the totality, it is not the contract provided for excavating in the verge, not the asphalt. Therefore, it was a valid variation. And in terms of the variations, there's extensive analysis of same in the respondents' submissions before the Court of Appeal at pages 12, 17 to...
Can I just understand this?
Sure.
You've taken us to P19, which states the rates for excavate, lay, etc. shall include, and then, as my lord has said, you refer to P18, which there says that the contractor is to price the items provided in the bill of quantities to cover for excavation in rock, as above defined. So the contract is, or this document rather, is contemplating excavation both in rock and not in rock. And the contractor is to price in the bill of quantities for excavation in rock. So I'm not quite sure what you get out of this, these 2 pages.
Well, it's respect what we're, the reference to this is that the contract did not provide for cutting in. It was never envisioned that we were to cut into the roadway. In terms of provision as to if rock encountered and that all those other issues, I appreciate that my lord is referencing.
I mean, as I understand it, your client was responsible for the design of this project.
And
so was it?
That is where, yes.
I mean, so whose responsibility was it to decide whether the pipe would be laid below the verge or below the roadway?
We are respectfully submitting that the contract and the record will reflect it is the appellant in terms of the designs, because there would have been submission preliminary designs where the line is to be located was determined and instructed by the contractual provisions to be on the verge. That was not, so the design otherwise.
Where do you point to back that up? where do you say that the employer required it to be laid under the verge rather than under the asphalt?
Well, Milady, my reference would have been, and if I take my Lord and Milady to page 553, when we look at the specifications,
553.
553.
The trouble is we don't have the drawings.
Yes, please, Mo, and that I appreciate, and I understand the difficulty, but we are saying those drawings are what was supplied by the appellant.
Isn't there something that says that these drawings are only indicative? It's not. We've referred to that.
Lady, unfortunately, I can't identify.
Well, I can help you with that.
Particular, yes.
I can help you with that. That's page 136. In the invitation to tender, note that the pipe routes shown in the attached drawings are indicative, and it's the responsibility of the contractor to confirm the final routes with site investigation and field surveys. That's page 136. That's the invitation to tender.
Yes, please, ma'am. And in that instance, we will be saying
so those are the same drawings that are referred to at 553, are they?
yes. And if that is so, that is our designs that were used to say where the pipeline is to be determined, that would draw confirmation that it was in fact a variation if it had to be changed to where it was. Because if it is that we are saying the engineer acknowledged, I don't think it's refuted, that the engineer is saying that he acknowledged there was a variation to now cut in the roadway. If it is that we're accepting that the design and layout as accepted by client is where we are saying, and the engineer is the one who's confirming, I changed it, I said it's a variation, you have to cut here. It goes to show the engineer did not agree with where the respondent was saying the pipe had to be laid. And the engineer saying, I'm varying it to now go where I'm saying it's better. So we are saying that's a proper variation, and that's an instance which supports what we are saying.
I mean, there does seem to, it is fair to say that at the site meetings that you referred us to on 389, for example, there is evidence that Mr. Ferguson, who I think was somebody for the employer, the authority, seems to have been saying where he was saying the pipeline should be laid. 60%
Yes,
of
please,
it would be on the verge and the rest on the right-hand side of the road.
I'm grateful to my Lord for that identification.
And then a similar sort of thing on the previous page, I think, but how that ties in with the contract is another question.
Yes, please, Lord. But it's also in the totality of it, we are saying it is a valid in the whole spectrum of that matter of where the pipe had to be laid, we are saying it all comes down to it was a valid variation where the engineer instructed that it had to be where it took place. That was a variation. And we're saying that is fleshed out on the, it's a valid variation, and that is fleshed out in the printed record. If I may go further as to explanation, subsequent to determination, and I know that it may be determined that this is a self-serving statement from the respondents being their own claim, but it gives a genesis if the court accepts, because what happens is the trial judge, we're respectfully saying she made no determinations as to credibility. And we are saying, having accepted the evidence, and if it is that Raymond's, well, it's not if, it is that Raymond's Thomas evidence was accepted, he did provide a rationalization attached in his claims, which are attached to his statement, of case, as well as it is attached to his witness statement, the claims for package 1 and 2. He gives the justification and rationale for why the variation came about and the factual background, which is very important, please, my lord and my lady.
Where is that in the bundle?
Yes, it's at page, for package 1, it's at pages 708 to 723. And for package 2, it's at, well, it's mirrored. So you may only need to look at 1, but for package 2, it's 724 to 743.
And under what provision of the contract does the obligation to pay this money arise, do you say?
Well, we are saying, having been a valid, and the intention is to go in that in a little more detail later on, but to just summarize, it was a valid variation under section 3 and 13 of the general conditions of contract.
With a price agreed? Was there a price agreed?
Well, we are saying the court of appeal correctly found that the engineer had the final, had the authority, and when this court and the court of appeal would have looked at it, he is empowered to make certain determinations. I know my friend... Well,
even if that's right, I know you're coming to that, but did he make a determination that these particular prices were payable for particular items of work? Where do we find his determination of the price under the contract?
Well, we are saying this is where the appellant is complicit in non-compliance with the procedures. He ought to have, on this 3.5, but he being the appellant's agent, we are saying he ought to have, having received all this information, proceed otherwise.
Okay, but I just want to understand, your claim is put as a claim for an agreed sum, a contractual sum due under a contract. So you need to be able to show how, under the terms of the contract, this sum was agreed to be payable. And I'm not at the moment sure when it was ever agreed to be payable, even by Mr. Paul, assuming that he had authority to agree anything. When and where and what document or on what occasion did he agree that these sums would be payable? Because I don't think he ever did.
Well, my lord, I don't wish to create any evidence. However, in the witness statement of Barry Paul, he does say at paragraph 33, which is at page 85 of the electronic bundle. During the months of December 2007, no further works were carried out on the project. And between the period of January to March 2008, I attended meetings held between the claimant and the defendant in order to address monies owed to the defendant. But my position in these meetings was that the claimant should be paid for the additional works done and costs incurred, including the extra volumes of sand and crusher run used in the project.
Okay.
The defendant was getting a quality installed product. I'm saying he made a determination. However,
well, that is not evidence that he made a determination. He doesn't say there, I reviewed these, and I said that such and such a sum is payable under the contract. He just said he came along and attended meetings and said that the claimant should be paid for work done. But that's not the same as fixing a price for the work in his capacity as the engineer, is it?
I do appreciate what my lord is indicating. However, we are relying on it for the fact that whilst an exact price was not determined, there is a determination, and he, having held that position of engineer at the material time, a determination that they are entitled, it is a variation, having accepted his evidence, and that they are entitled to payment for sale. The record will also reflect that he was informed, and there.
Well, what was the date of the determination of the sum claimed on the page you showed us? You can't point to a date because there isn't any evidence of a determination, as I understand it.
Well, all I can rely on, please, my lord, is that paragraph 33. And
that's the paragraph you rely on is 33, is it?
As the confirmation of the engineer himself is saying that I agreed that they should be paid. I'm not saying that is the only evidence, but at this point in time, I'm saying this is the evidence.
But that's assuming that the monies were already owed to the defendant. And nothing was owed until he had made a determination as to what price was payable under the contract.
And this is where it's very important that I wish to take my lords and my lady to another provision in the contract. It was not raised before the Court of Appeal, but it forms its way in the contract and it's very relevant, and we are determining based on what is provided for in the contract. In the conditions of particular application, part 2, and it's at pages 418 to 419. It's very important, please, my lords and my lady.
480.
18, I think.
418 to 419. In the conditions of particular application, which are prepared to supplement the general conditional contract and as to employ specific needs and requirements.
So these are amendments to the standard terms to make it bespoke as between these parties, basically.
Correct, please, my lady. And we are saying, it's in the genesis where I was going was that the parties agreed to treat this contract in a certain way, and this provision encapsulates that agreement, that it was a flexibility and fluidity.
Which paragraph which point are you showing us here?
So I'm saying there's an inclusion of subclauses 3.6 and 3.7. Let me just go to page 4.
Oh.
Right.
So 418, is it?
418. Yes, please, my lord. Right. There's an inclusion for proposals, and there's an inclusion for management meetings. When one considers those provisions, it speaks, the contractor's representative shall notify the employer's representative at the earliest opportunity of specific likely future events or circumstances which may adversely affect the work, increase the contract price, or delay the execution of the works. The employer's representative may require the contractor to submit an estimate of the anticipated effect of future events or circumstances, and or the proposal or under this subclause 13.3. The contractor shall submit such estimated proposal as soon as practicable. The contractor's representative shall cooperate with the employer's representative in making and considering proposals to mitigate the effect of any such event or circumstances and carrying out instructions of the employer's representative.
Well, it was never done, was it? I mean, that's a point against you.
Well, no, please, my respectful submission, please, my lord, is these provisions, as well as the 3.7, these provisions speak to that discussion and a group arrangement facility where we work as on-site, and to make it easier as to the general conditions and contract provides a strict compliance with written approvals. This speaks to me submit proposals.
But I thought you accepted that there was, well, perhaps you don't. I thought you weren't putting your case on the basis that there was a proposal by the contractor's representative, but you were putting your case on the basis that the engineer unilaterally instructed a variation.
Agree, please, Madam. We are not saying that. We are saying no request there was no submission of proposal. There was no request for proposal.
Right.
However, why I'm referencing is not that it is a proposal. The other reference is to management meetings, which, if I may, not to have to read it out, when my lords read it, if they agree with my submission, is those provisions speaks to active engagement between the parties on site if issues arise, as they did in these circumstances, and the parties working with each other, and wherein it is the employer's representative who had the final determination, because there's a specific reference here. And
is that the same as the engineer, or is it somebody different?
Well, that's the question.
Somebody different.
Under this contract, I believe there's only one engineer.
So it's the same. You say that's the employer's same word as the employer's representative.
Yes, please.
Well,
in terms of this contract envisioned that the representative on site to give issue and
Yes,
issue
but
instructions and make determinations
It's a
is
defined term.
the engineer.
So
There's
where do
no
you
other
say?
person. If it has to reference employer's representative, it would be him in that position, and there's no disputed fact that he was on site and he was the one dealing with it. They never refuted in terms of the appellant. So we're saying,
Can you, because I'm looking at page
what I'm referencing
114.
to is that at
Mr.
the end
Ali,
of the
Mr.
last-
Ali, I'm looking at
Yes.
page 114, and that says the employer's representative is Mr. Eustace Ferguson. So why do you say that the employer's representative is Mr. Paul? You may be right, but I'm just wondering where it is.
But I'm saying why then, whilst it may be said he's the representative, and let me see page 114.
Well, that would tie in with the fact he was in that meeting that site meeting, talking about where the pipeline was going to go.
I appreciate that. However, we are saying the person who is actually on the contract treating with, which cannot be distanced from what is proven on the factory record. A representative of the employer was Mr. Paul, who's the engineer. However, even if we were to say that.
Well, he's meant to be sort of at least semi-independent, the engineer, not just a representative of the employer.
And even if it's Mr. Ferguson, we are saying the contract still provided for. And I appreciate the court is saying, okay, if it is not Mr. Paul, but we are seeing references to discussions and meetings, even where I drew reference to that paragraph 33 of Mr. Paul's witness statement, he's saying he had meetings. What is essential, we are saying, even though the court did not explicitly say it, as to the adverse influence that Mr. Boyce or Mr. Nanan was never called as a witness or witnesses in this matter, despite even in the witness statement of Mr. Nims, who is the appellant's sole witness. There's no account for why they don't come. We are saying the adverse inference can be made that these meetings did occur to agree to what transpired in relation to those variations, the discussions as the approval of the works, and that is why, well, the inference can be drawn. That is why they were never called. And that is where we are going with that aspect of the evidence, because there's no evidence whatsoever that came out from Mr. Nils. He never gave first evidence as to what transpired on site or what transpired during the arm. So therefore, we only have the evidence of the respondent's witnesses and Mr. Paul, and which we are saying no determination was made as their credibility. So we have to accept it as it may, that meetings did occur, variations were approved, and agreements to pay were made. Mr. Ferguson himself could have been called as a witness. That did not transpire. So we are left with that state of circumstances where that adverse inference ought to be made, that everything that is being said by the respondent did transpire.
Well, I haven't seen anything yet said by the respondent that Mr. Ferguson was notified that the likelihood of an increase in the price, and that there were some meetings that took place or suggestions that meetings take place to discuss all that. Nothing of the sort. It's all said it was all done by Mr. Paul.
But look, if the court is a practical issue for the court, because I agree, there's no evidence of that. But if we are saying this is the representative assigned to the project, and we also have evidence of Mr. Nanan, Mr. Boyce, Mr. Nanan, site technician, Mr. Boyce, project director, if it is that they did not participate in active engagement in this contract, they would not have been exercising their function themselves, which shows the complicity of the authority in its own sense of what transpired. So they blame the respondent for all these non-compliance with procedural. However, we have no evidence whatsoever of the appellant that they were completely complying with the procedural requirements as well, because it's not a one-sided contract, there were procedural provisions that also engaged the appellant, which they themselves did not. We see termination of contract. My friend speaks a lot to us. There is a counterclaim in this proceedings. There's certain provisions, 15 and 2.5 employers' claims. No such claim was ever made. Those provisions, we are saying the appellant seeks to rely when it suits them for the fact of non-compliance. But we can see they were entirely complicit throughout this contract, and that's what we are saying it will be proven in the factual record. They were complicit in not following through with the procedural requirements in this contract. What is being said on the record as to the factual matrix, that is the only evidence that comes out from the respondent, witnesses, and Mr. Paul. There's no, whilst there may be the inference by the appellant now that there may be some mispropriety on his part, Justice Kangaloo, the trial judge, never made a determination. There's nothing to show that. So we have to accept this evidence as is. And we are saying the evidence as established proves that there was this active engagement, there was these determinations as to the variations, there was determination made by this representative, and there were meetings. And I did hear my lords and my lady reference, well, if there were monthly reports, where are those reports? And I think one of my lords would have accurately said that would also have been part of the records of, if it had in fact been, it would have been part of the records. I know in retrospect, it would have been best if that evidence was there, but we are saying the only evidence factual without being refuted or rebutted by Mr. Nims, who has no first-hand knowledge. The only evidence that we have is Mr. Barry Paul, the engineer authorized at material time, saying that these things actually occurred, and the corroborating evidence of the respondent witnesses. And we're saying the court cannot, without any refuting or rebutting evidence, does not have anything to say. It can distance itself from that evidence.
Mr. Ali, can I ask you this, please?
Yes.
Whether or not something is a variation is a function of the contract terms. If we assume that one of these claims is not a variation, do you accept that the fact that Mr. Paul may have thought it was is irrelevant? If as a matter of contract it's not a variation, then what Mr. Paul thought doesn't matter, does it? Well,
We are saying that the contract, if it's not a variation, the contract provides for payment. So there will be, even we speak of contingencies, even if it is not a variation, it ought to be paid for. And in terms of what we transpired, there were different rates and terms, rates as to what transpired. The engineer at the time of those things happening, which we will rely on for the complicity of the appellant, and why waiver and estoppel applies.
I'm not sure what the answer to my question was.
Yes, sorry. If
it's not a variation as a matter of contract, then there's no entitlement to additional monies.
Well, we are saying the works, even if it's not variation, it was additional works, please, my lord, which entitles them to payment, and the acceptance by the engineer that they were additional works, even though it's not crouched as the fact of variations, these additional works and being determined by the engineer as additional works with the acknowledgement that additional payment is to be made, and the contractor having had those representation assurances that it is additional works and it is to be paid for, and acting upon it to carry it out on the basis that there's evidence from Mr. Paul saying, carry out the works. We had meetings and discussions. He's reporting to his superiors. There's nothing coming. There's no evidence that the appellant in any way gave notice or indication that Mr. Paul was acting outside of his authority. These works are carried out. The only evidence we have is these. He is reporting. He is saying all these things are variations, additional works, agreed payment, and they do nothing to stop it. that is where this principle of waiver and esper also applies. So I don't know if that assists, my lord, in identifying where the respondent is minded in terms of that aspect.
Thank you.
Yes. All right. So I don't, in terms of the actual variation, because it will take a lot of time, it is reflected in the appellant's submission before the Court of Appeal in detail why we are saying it is variations and amounted to variation. So I don't intend the court to take the court through that at this time. So our submissions, in the circumstances, the necessity for the disputed works arose directly from unforeseen site conditions and the need to progress works. The engineer's role, Mr. Barry Paul, on site, was expressly, he was authorized to treat with these variations when the Court of Appeal rightly determined that he was in a superior position to have done so. Critical is Mr. Paul's own evidence, which we are seeing at page 86 of the record. He says as paragraph 35 of his witness statement, at all material times I worked on the project, I acted in my capacity as site engineer for the defendant, and all material times the defendant had knowledge and or was made aware by me of how the project was progressing and the variations. And at no time was I ever directed or informed by the defendant that I was acting outside the scope of my duties. When asked by the trial judge about whether it was a contractor who came to him regarding the unsuitable material and the claim was an unforeseeable condition, Mr. Paul answered, and this is at page 1038 to 1039, the explanation is simply this: the contractor did not come to me and indicate to me that the material is unsuitable. I, being a site engineer on site, I observed that the material is unsuitable. And with the authorities' interest at heart, I knew that to put back that material in the trench would not have been in the authorities' interest. We are saying the appellant's sole witness, as to Mr. Paul's authority, under cross-examination indicated these things. Mr. Dims, in his answer, confirmed that Mr. Barry Paul, and this is at page 1134, Mr. Barry Paul was the appointed engineer of WASA and had the authority to instruct variations. I may be paraphrasing, and that's subject to confirmation by my lords. Mr. Nim, in answer to the question whether a request was made or the engineer instructions pending determination of variations, being that if it approved or not, the work must continue according to the contract, stated
so
should
they
not
were
be made in
perfectly
progress.
happy to put all this unsuitable material back in the trench, and it was Mr. Paul who noticed that it was unsuitable and told them don't use it as backfill. Is that what you're saying?
That's not what we're saying. Both parties are working in the interests of the project, and when that is identified, that's why I was referencing the management meetings, and that there was that active discussion. The evidence fleshes out that anytime an issue arose as to the need or requirement for variation, there was a discussion. There was never unilateral acting or in best interest of or bad faith on the part of the respondent to say, well, I'll do this work to get some extra money. We have the engineer indicating, I identified it. He's confirming, there's nothing saying. He's actually saying, I identify it, and in the authority's best interest, I gave those instructions. So we are saying that in itself indicates, if the court is minded to say, well, it may be the contractor was looking at its best interest to have these variations on it unilaterally determine these things. Mr. Paul's evidence confirms the position that is he who is making determinations in the best interest of the authority, and they were following instructions, please, my lady. Moving along. The appellant's argument regarding lack of formal written instructions is defeated by the fact that the appellant, through its engineer, waived strict compliance. Oral instructions were received. Mr. Paul, in his capacity as engineer, issued oral instructions for the variations and did not request written proposals from the respondent. We are saying subclause 13.3 of the general condition contract only requires the respondent in kind if the engineer requests a proposal. Since no request was made, no written response was necessary. Yeah. We are saying the appellant acquiesced to the performance of the works and received accepted benefit without objection. This is clearly supported by the principles of waiver, the contractual requirements, and we would have mentioned in our written case, our reliance on management solution, the dicta in management solution versus Bennett, where it said, even if these variations were oral and not evidence in writing, the work required by them was carried out, and if it can be established that instructions were issued by or on behalf of Mr. Bennett in that case, the resulting work was carried out by agreement with the result that the contractual requirements and variations should be evidence in writing was weighed by both parties. There's an argument that my friend was alluded to in his written case, speaking to the in Sharp versus Sao Paulo Railway, the principle, and from Keating, that the lump sum nature of contract makes it that the works performed on the outside of it, you cannot claim for any extra sums. We are saying this applies where the contractor undertakes an entire project for a fixed sum, proposing that the full scope of the works was known at the material time. We are relying on the fact that the contract was executed after the commencement of the work. The pre-construction meetings confirmed only preliminary designs were issued and full scope was not yet finalized, and site visits were limited to familiarization with the site, not with confirmation of the scope. We then move on to the validity of the engineer's authority. We are saying the evidence demonstrates that Mr. Paul, throughout the course of the project, acted as the appellant's authorized representative and engineer under the FIDIC terms. He issued directions, supervised works, and approved modifications in the field, all with the appellant's knowledge and without objection or reservation at the time. Indeed, the respondent's evidence of that of Mr. Paul himself establishes that each of the disputed items was executed at the engineer's instructions or with his express approval. The contract conferred on the engineer the authority to instruct variations. And we are saying the absence of written order was a matter of form, not substance. Substantive authority, FIDIC Yarrow Book framework, clearly vests the engineer with the authority to instruct and initiate variations. We rely on clause 3.3 of the general condition contract. The engineer may issue to the contractor at any time instructions which may be necessary for the execution of the works. And this provision also goes further to say the contractor shall comply with the instructions given by the engineer or delegated as assistance or any matter related to the contract. We then place reliance on clause 13.1 of the general condition of contract. Variations may be initiated by the engineer at any time prior to issuing the taking over certificate for the works, either by instruction or by request from the contractor to submit a proposal. And I believe I mentioned there was no request for proposal, nor a submission of proposal.
And so how do you deal with 13.3 then, if there was an instruction, when it says at the bottom of that page 194, upon instructing or approving a variation, the engineer shall proceed in accordance with clause 3.5 to agree to determine adjustment to the contract price and schedule of payments. You don't say, do you, that there was ever any adjustment to the schedule of payments and contract price done by the engineer?
No, please, no. Our reliance is on, and that is where the equitable waiver estoppel provisions, where the engineer, and we were saying the appellant was complicit in the non-compliance with the provisions. And if there was non-compliance, it was the appellant themselves who would have not engaged that provision because it was their responsibility under the contract. So
well, the problem is it leaves you with no claim, this particular non-compliance, because if no price was ever agreed, there was no price ever had to be paid to you. So no good just saying you waived compliance with it. I mean, that just still doesn't give you a claim, does it? There's no sum ascertained to which you can claim an entitlement.
My Lord, whilst I appreciate what my Lord is saying, I disagree with the fact, and we're relying on the factual matrix that the manner in which the work was engaged and the performed on site, get the works done. That was and we can't ignore the fact of that. And that's where the courts recognize the need for equitable principles to apply. Even if not pleaded, the equitable principles is where I'm encouraging you. We need to get these works done. Execute my works, get it completed. Active engagement by your representative on site, empowered, authorized by the same contract to issue those instructions. I am not complying myself with the terms and conditions. You can't make it mandatory on me alone that in carrying out your instructions, that I alone had to comply with the provisions. If we were complicit together, it ought to be, if those, and we are saying the record reflects that it was never rebutted, that the appellant's own engineer instructed those works as variations. And he's also saying, we are saying that his evidence also reflects he agreed that it was payment. When we look at his evidence even further, he is saying those, even though he agrees there's additional payments, because of the progression that he will get the work done, I think that was put on the side. It will be dealt with at a later point in time. That was the arrangement and agreement between the parties, and that is where we are saying equity and the legal principles set out in the authorities we rely on, and our written case fleshes out that it cannot be you are not entitled to payment, where such circumstances exist, where you instruct the variations, you acknowledge agreement as to payment, and then later on come to say, I'm not strict procedural requirements are required, I'm not paying you. Those are the very reasons why equity was created, to protect against those instances. And I believe the safeguards that are mentioned throughout do not apply to this, because there's no evidence that they did not have notice. We are
What about then?
Evidence.
What about clause 20 then? Because that tells you what you're meant to do if the engineer doesn't determine the price.
Well,
which is to, within 28 days, invoke that procedure. Do we just apply some equitable principle that allows us to forget about that clause as well? If so, what is it?
We're saying, and that's why I brought to the court's attention, I don't know if it finds itself in there was a recent authority in Gordon Winter Company Limited versus NH International Limited, Privy Council Appeal number 050 of 2024. It ought to find itself in the proceeding bundle 2185 to 2191.
My bundle stops at 2184, but
Is this a supplementary?
is a supplementary?
Yes, please, Malone.
Gordon Winter Company.
Yes, please, Malady.
That's in
We're saying this.
Authorities.
Okay.
Right.
I'm getting there.
In that authority, at paragraph 13, this case had to deal with some aspect of a clause 21 claim, and in the board referencing to that issue indicated.
That's one of yours, isn't it?
At paragraph 13, I'm reading towards the end. One possibility aired by Mr. Mutu is that it might be said that if there were to be a variation of the works, an additional payment.
I'm sorry, can you give me the paragraph?
Which
again?
paragraph?
13, please, my lord.
13. Sorry?
Yeah.
13.
So I'm reading towards the last paragraph a last sentence of that paragraph on that page. One possibility aired by Mr. Mutu is that it might be said that if there were to be a variation of the works, an additional payment, a notice should have been given by GW to NH under clause 20.1 of the FIDIC standard terms. But it's hard to see any force in that submission, given that there was no dispute that even without a clause 21 notice, having been issued by NH, a variation which was required as evidenced by letter of instruction dated 13 February 2006 from Turner Alpha Limited, employer's project manager. By analogy, we are saying the instruction from Barry Paul is similar to that requirement that a variation was necessary. And then going further,
This is for the purpose,
put another way.
this is for the purpose of making a quantum merit claim, is that right?
Yeah, I do. I appreciate that, but I will draw reference to why I'm referencing this provision. And put another way, it was clear from as early as February that GW and NH were not adhering to procedural provisions in the standard FIDIC terms. That is further shown by the fact that the dispute resolution and arbitration provisions under Clause 20 have not been complied with by the parties. Why I'm referencing that is that the board, well, three panel members in this instance, is acknowledging that when there is non-compliance with the procedural provision, it did not exclude the party from a contractual claim
But
to receive payment.
There, if I've understood the facts right, there wasn't a dispute that there was a variation.
Yeah.
Whereas here, that's front and centre.
I appreciate that, and I accept that. But what we are saying is if the court accepts the evidence in this case, that is, it cannot be rebutted, was not rebutted, that variation, we're saying the only evidence that can be established in this case is that the variations pursuant to be instructed by its authorized engineer has to be accepted a variation. We are saying the principles alluded to here apply that if the party is complicit in non-compliance with a section 21 notice, it did not preclude one from being able to be paid under your contractual entitlement to payment. I think that was in reference to one of my lord's questions as to whether or not we can still claim an entitlement to payment if non-compliance with 20.1 provisions.
But there it was agreed by the project manager. That's that would be the equivalent of Mr. Boyce here, I think.
Yes, exactly.
But we have no evidence that Mr. Boyce agreed this, other than Mr. Paul saying, oh, well, I told them all and nobody objected. But do we have anything from Mr. Boyce saying he agrees to these payments?
Emily, we are saying that is the problem of the appellant, not the respondent, for the fact that even in their evidence by Mr. Nim, he accepts the role and function performed by Mr. Boyce and Mr. Nana. No explanation whatsoever is given as to why they were not called to give evidence. We are saying the only adverse inferences that he was aware, there is the acknowledgement, he approved, because we are saying the instruction, and part of our argument is the instruction itself from the authorized agent is on its own, carries with it the necessary approval because he's authorized. That is part of our argument as well, fleshed out in the written submissions, that he being authorized onto himself and being permitted under the contract to issue those instructions is approval onto itself. And the fact that there is no evidence whatsoever from the, even though we understand the appellant's case was structured, basically premised on the fact that his was not variations. There was no evidence to refute that Mr. Paul acted outside his authority. Now there's a large argument having regard to the findings and what the evidence alone establishes. That may be the only limb they have to rely on now, that procedural requirements and non-compliance with as conditions precedent to payment. However, we say that cannot follow through for what was mentioned. Please, Milady.
But is it not the case that Mr. Paul's only authority was to act in accordance with the contractual terms? He had no authority to act outside the contractual terms because he had no authority to alter the contractual terms as the contract expressly provided.
And I agree with that indication, please, my lord. And it is all part of a written case that what was instructed was never amendment. It was even though it was not included in the scope of works, the variation works, it was pursuant to fulfilling the scope of the works, and the engineer, as indicated in those provisions cited, 13.3, 3.3 provisions, and the specific provisions included in the condition of particular conditions, or no, application, it speaks to what is required to get the works done in layman's terms. And we are saying he was fully authorized to do those things, and that is what transpired.
He was fully authorised to act in accordance with the contract, wasn't he?
Yes, please.
But he had no authority to act otherwise than in accordance with the contract.
And I understand what my lord is saying. So it's our respectful submission that everything that he did, meaning instructive variations, was pursuant to his.
Well,
within the contract.
I don't understand how you can say that, in that he didn't follow any of the procedures that the contract requires to be followed.
Well,
He didn't. There was no instruction in writing. There was no written notification. There was no consultation with the employer and the contractor. Absolutely no compliance at all with any of the contractual requirements.
my lord, there's a deeming provision in clause 3.1, please, my lord, and that is what protects the.
Yes, but that doesn't permit him to act outside his authority in departing from the contract. Because under the terms of the contract, he can't alter the terms of the contract.
And we're saying he never altered the terms. And if I understand what my lord is saying, if it is, there was an issue, and the Court of Appeal touched upon it in his judgment, if there was an issue with Mr. Paul acting outside of his authority, that was an issue between him and the appellant.
Well, it wasn't, because the contract with your client required particular procedures to be followed by the engineer and by the other parties.
And it's our respectful submission that given the provision 3, clause 3, and clause 13, he was authorized to issue. Yeah.
So which
3 and 13 of the general conditions of contract.
Which part of 3 are you referring to?
Okay. So 3.1 gives him the authority. Let me just.
It's on, yes.
Yeah. Yes. The employer shall appoint the engineer.
Yes.
Yes, the engineer may exercise authority attributable to the engineer as specified necessary to be implied from the contract. If the engineer is required to obtain the approval of the employer before exercising his specified authority, the requirement shall be as stated in particulars of condition.
Well, that's not. I'm sorry, let's start again. So which bit of 3.1 are you referring to? Just help me there. Oh, I see. However, whenever the engineer exercises a specified authority for which the employer's approval is required, you mean?
Yes. So, however, yes, the employer shall be deemed to have given the approval.
Yes, but the contract in the relevant provisions doesn't require the employer's approval.
Well, as I understand
I mean, that's dealing with a case where under the contract it says that the engineer requires the employer's approval for a particular step. But I don't think that is relevant in the provisions we've been looking at.
I may not be understanding exactly where.
Well, the point I'm making, to make it clear, is that the second paragraph of 3.1 says the engineer shall have no authority to amend the contract. And what that means is that he has no authority to exercise his powers other than in accordance with the contract, so far as relevant.
Correct.
To the extent that he doesn't exercise powers in accordance with the contract, he's to that extent amending the contract. And that's something he's not permitted to do. And that's a term of the contract.
Correct. And I understand and there is in the respondent's written case, the argument that the variation of the works do not and cannot be construed as amounting to an amendment of the contract. There's the reference to Hudson Building Contractors, and in the Bennett case, there's reference to I have to pull
We're
it.
talking about different kinds of variations. We moved off. We're not talking about the scope of the work now. We're talking about
Yes.
the engineer's ability to dispense with all the requirements for writing and consultation. We're talking at the moment about that variation of the contract. And where do you say that the engineer is authorised to amend the contract by saying you don't have to put in a proposal, we don't have to consult, I don't have to determine a price, you just put in an invoice and that's what you're entitled to pay. Now that would be a substantial amendment to the terms of the contract, and where do you say it says that he can do that?
I appreciate, I am now guided by where the court is directed. And we are not saying, our argument is not that that is an amendment, that what the principles and the law that are cited, that's a non-compliant. What is alluded to there, whilst I understand what my lord and my ladies are saying, that on its own, by him not doing it, he may be implying or expressly saying, I'm changing contract that is no longer required. But we are saying no. Is the complicity of the appellant for non-compliance. And when the court, when we look at the authorities that are cited in the respondent's written submissions, there's a series of non-compliance. It was never treated that the party who did not fulfill the requirement to give written notice was amending the contract. It was considered in the context that it was a non-compliance, and whether that created a bar because there was non-compliance, whether you're entitled. And that is where the equitable principles are referencing that even where there's none, where there no oral modification clauses, when we look at those references, it speaks to if it is that the works were made known, approved by the employer or their representatives, they cannot now claim that they have knowledge of it and it's not binding on them. That is where our argument is crafted in that area.
So how do you say the employer approved the non-compliance in this case?
And we are fully reliant on the fact that its own engineer with the Court of Appeal.
But that's just the problem. The engineer didn't have authority not to comply. So you can't point to the engineer, can you, as the agent of the employer and say he as the employer's agent has approved his own non-compliance with the contract.
I appreciate, but that is where we are drawing reference to the deeming provision. Please note that we would not know that there is an issue. That's internal. At the material time, we would always be operating under the premise that those approvals are obtained. We would not know it, please, my lord. And that's the genesis. Do the works, complete works. We don't know that there's no indication of non-approval. And that is where the equitable principles apply, please, my lord. There's nothing up to and termination, nothing indicated, even up to termination. It only finds itself as a defense in this case, that and alluding to the authority or that there was non-approval. Prior to the termination, there was no issue. Works being completed, works being done. The clear evidence is that the appellant was fully informed, had knowledge, never stopped, and that is where the equitable principles of acquiescence and waiver apply, please, my lord. Number lady.
Can I ask you a question about the authority you cited to us, the recent decision of the Privy Council? Because I was looking at paragraph 5.2 of that, which seems to be the basis of the claim, which refers to a clause of that contract, clause 12.3, which deals with how the contract price would be worked out when there was a variation to the work covered by the contract, but no figure for the varied work was agreed. And there was a clause that said, quoting from the bottom of the paragraph, if no rates or prices, whatever, it shall be derived from the reasonable cost of the work. So basically there was a contract clause which said you're entitled to the reasonable cost if one hasn't been agreed. Is there any similar provision in our contract? Because on a quick look, I couldn't see one, which says that if there's a variation of the contract, but the engineer does not determine a price, nevertheless, there's something you can point to that says there's an obligation to pay a reasonable price for the work, or something in the contract equivalent to the 12.3 here.
So it would be remiss of me to indicate that I did identify that prior to here, but however, as to what the respondent is relying upon, it is fleshed out in its claim, and there is indications as to how the justification and the rationale for why the payments are to be made are fleshed out in its
By reference to what term of the contract? You see, I'm trying to find the contractual basis for your claim, what the term of the contract is under which you say there's an obligation to pay a certain sum of money to your clients. And at the moment, I haven't found any clause in our contract except the one which it presupposes that the engineer has determined a price when given an adjustment to the schedule of prices and payments and so on, which never happened. So is there any clause equivalent to 12.3 that says, anyway, if there's been a variation, let's assume instructed by the engineer, you're entitled to a reasonable sum, something like that? Because I couldn't see it in the clauses when I've been looking at them just now. But
I think it's a yes or no question.
yeah, if you're aware of any clause that is there any clause you're relying on in the contract as the peg for your claim, it will be helpful for you to identify it.
If I may, I know I have a little more time. If I could find that, I will come back to it. But I will move on. I appreciate where the court's direction is, but save and except for what that issue has arisen, we are saying our reliance is on the equitable principles, and that is where we're premised on. And that is where the Court of Appeal ruled on our entitlement. I understand what my lord and my lady is asking. I will attempt to see if I can identify it. If not, then the answer will be, I have not identified.
Okay, thank you.
Yes. So what we are moving back onto the issue of the appellant approval, and if so, right, if the approval was void, we are saying there's a factual and legal framework under the FIDIC contract which allows for it to be binding on the appellant. We're saying the variations were authorized and executed by the appellant's full knowledge. Mr. Barry Paul, acting as the engineer, his contractual authority under the FIDIC clauses 3.1 and 13 remained intact, enabling him to issue oral instructions before the taking over certificate. He contemporaneously, from his evidence, reported these variations to his senior officers, Mr. Boyce and Mr. Nanan. The appellant's only witness, Mr. Nims, was unable to challenge this evidence. The appellant produced no testimony from Mr. Boyce and Mr. Nanan, who were best placed to contradict Mr. Paul. The Court of Appeal correctly identified that the clincher of the case for the respondent, however, was the evidence of Mr. Paul, who confirmed what the respondent witness said, but went further to agree that the appellant, through him, had approved the changes. In consequence, the factual matrix reveals a clear chain we are submitting. It reveals a clear chain of instruction, knowledge, and acquiescence by the appellant and its authorized agents. We are saying there's references, and we are saying these authorities that are referenced by the appellant give support to our argument. And NH International, we're saying it's distinguishable. NH International, no evidence of notice of employer's claim existed. Here, there was clear repeated notice to the appellant through its own officer. In NW Rock Advertising, the appellant assigns Rock to invoke strict enforcement to no oral modification. However, that is fundamentally different. It involved a private license agreement with a express no modification clause bearing oral variation. The present contract authorized the engineer to give binding instructions, including oral. There was no attempt to vary the contract outside of its terms. That did not permit oral, that he can give instructions, right? More importantly, Lord Sumton, JS, recognized the equitable safeguard of estoppel and waiver. A party may be precluded by his conduct from relying on such provisions to the extent that the other party has reasonably relied on that conduct. Those safeguard applies squarely here. The respondent relied to his detriment on the engineer's approval. The appellant stood by with knowledge and acquiescence. The doctrines of waiver and estoppel apply. We are also, there was also reference to PBS Energero versus AS Vesta. We are saying, notably, the judgment and PBS Energero also expressly acknowledge that exception arise where waiver or estoppel are engaged, and that is at page 941 to 942. We are saying the objection of no oral modification of formal variation clauses is to protect an employer from unwitting liability for unproved works. The rationale has no application here. The appellant was fully aware of the variations through its engineer and senior officers. It accepted the benefit of those works. Its conduct was consistent with approval and payment. The doctrine cannot be used as a sword to defeat liability where the employer had actual knowledge and allowed reliance. The doctrine of waiver and estoppel are directly engaged. By its conduct and silence, the appellant waived the requirements for written approval. It permitted oral approval to be given, observed performance, and raised no objection. We are saying that is the only factual matrix that can be discerned from the evidence in this matter. The respondent acted...
Can I just ask you on this issue? In your case, page 1557, paragraph 83, you say that the appellants were given oral and written notice via 2 letters and the monthly reports, and then later on, after the contract's terminated, we had these invoices. Is there anything else that you rely upon?
As to writing, no, please, no.
That's it. Whether that's oral and written notice, is there anything else you rely upon other than what's specified?
As to written notice, no, please, no. I can't say we have any document other than those.
We don't have any of the monthly reports.
No, please, no.
Okay.
And we don't have any reply to those 2 letters from Mr. Boyce, I don't think.
Well, there's a loop. Whilst there's reference to no knowledge, but there's a particular indication where I believe it proves full cognizance of the appellant as to the respondent's claim testimony, and it finds itself in the response to the pre-action protocol letter that was issued in these proceedings. It could be found at page 43 of the electronic bundle. And where it has, if my lords and my lady has found it, page 43. Yeah, there's some paragraphs with the title ECALS's recommendations on overpayment. Without prejudice above, as UBC well knows, in or about May 2008, Errol Clark Associates Limited and structural engineers and project managers, having been retained by WASA, made an assessment of UBC's claim for outstanding monies under the contract, while ECLA assessed UBC's claim for payment at $239,060 on package 1 and $1,503,177.60 on package 2. ECL has concluded that UBC has been overpaid for many aspects of the contract. Such overpayment took the form of payments for works not performed under the contract and payment of contingencies to current market rates rather than the rates that were initially approved under the contract. So there is a reference and there may be an indication, I know there was alluding to that, where there may be been notice or where there's evidence that the appellant was aware of these claims. this is like active acknowledgement from instructions. Well, a response has to be drafted or finds itself from instructions, and the instructions that find themselves where that there was an assessment or consideration of those extra monies owed to the and we are saying this evinces that there was acknowledgement and recognition.
Mr. Ali, that can't possibly be right, can it? This is simply an assessment of the monies outstanding at the date of termination. So that will be the contract sums. And then they're saying, well, in fact, they've been overpaid. So this is nothing to do with variations,
Well,
which word doesn't appear.
I understand there's no direct reference, but we are saying having had, we are the respondent's submission is premised on the acceptance that there's unrebutted evidence of Barry Paul, its engineer, indicating that at all times the respondent is aware of these variation works and his approval for payment. Therefore, when in the assessment, we are saying in this, it must find itself, and we are saying respectfully that this board ought to accept that when it's determining these claims, it is also determining those variations as part of that assessment.
But
that is where, yeah.
So this is in May 2008.
Yes, please.
So this is after the relevant work has been done for which you claim payment, is it?
Yes, please. I believe that's this yes, sorry.
So I mean, we know nothing. I mean, you've introduced this now. This is new as far as I'm aware. But so by May 2008, the appellant is aware of the work and seeks an assessment by Errol Clark Associates. But that I don't really understand how that helps you as far as approval of the works are concerned, as and when they are being done. I mean, I know this is actually before termination of the contract, I think. So the contract was terminated in May 2009. This is in May 2008. But it is after the work was done, isn't it?
Yes, but we are saying this is an respectful in the factual matrix of things.
Yes.
We are seeing this as an offshoot of the paragraph 33 that I read out from Mr. Barry Paul's witness statement.
This is page.
That he's saying page 85, where he's saying between the period of January to March 2008, I attended meetings held between the claimant and defendant in order to address monies owed to the defendant. My position in these meetings was that the claimant should be paid for the additional works done and costs incurred. We know he was terminated, and we find ourselves with this information in this response letter and as I understand from the factual matrix, this is the entity that took over the project engineering after the termination of Mr. Paul.
I see.
So this is, yeah.
I see.
Yeah.
Well, that's new to me. But, I mean, this is all going into the facts which are relevant to whether there was a waiver or an estoppel. Is that right?
Yes, please. Yes, please.
But these are facts which should be investigated at trial. I mean, if a waiver or estoppel is going to be relied on, that's a matter to be pleaded and then to be the subject of investigation at trial. I mean, you can't really just pull something like this out and then say, well, this amounts to notice and approval. There aren't any findings about this, are there?
Well, and that is where we are saying the evidence was available.
Well, it may be available, but was it actually the subject of argument and evidence at the trial?
Well, we are saying the cross-examination. The party is not caught off guard by the fact that the areas of cross-examination, if studied in detail, would reveal that the nature of the cross-examination as well
What shows that is cross-examination was being directed to something that wasn't an issue. If your counsel on the other side the fact that something's being asked about which isn't an issue means you don't have to worry about that part of the cross-examination.
But was this connected with the authority's counterclaim, which was also dismissed by the judge, and there was no appeal against that? So did these sums of alleged overpayment, were those part of the money that they were counterclaiming unsuccessfully?
Well, if we draw reference to what they're saying if you claim these sums from us, we are saying you were overpaid to the extent.
Yeah.
And, yeah. So, but we show, and now that is raised at the counterclaim, we say it shows the inconsistency. Whilst the appellant was relying on saying that we didn't follow procedural requirements as to entitlement to payment, it's inconsistent of their own case to have counterclaimed and say, well, I'm claiming from you monies due under the contract for overpayment. That can't find itself as a rational, logical thing to do.
Well,
if I'm saying I don't.
Yeah. No, sorry, I think you've got 5 minutes left, so if you want to sort of bring your submissions together.
Yes, please. So we are saying the areas of waiver and estoppel have been clearly established. We have the authorities fleshed on our submissions. We are saying in terms of the appellant's submission that the procedure, the condition precedents to payment must have been complied with to entitle our clients to payment. We saying that cannot of itself be applicable in regard to judicial authority, such as approbation, reprobation, approbation, the principles. I can't remember the authority right now, but it is mentioned in our written submissions. You can't blow hot and cold. In one instance, saying perform the works, you will get paid, which we are saying its authorized agents was doing, and then seek to rely on strict contractual provisions. We are also saying the authority of VIM Engineering, even though it's from the Court of Appeals Singapore, does provide significant judicial guidance to this court as to the modern approach where instances such as this have occurred, where there's clear evidence that oral instructions were issued. There's nothing to contradict that it was known to the employer that it was instructed on their behalf. They allowed it to be performed, accepted the benefit of it, and then seek to rely on strict procedural requirements. We're saying VIM Engineering, and we are saying all the authorities, and this is where the exception comes to this case. In no other case that ever came before that I have seen did they have the engineer come, and that is where I think the Court of Appeal is correct. The clincher in this case is Mr. Barry Paul came and gave that evidence, which has not been rebutted or refuted, and we are saying there's nothing to contradict what has been said. And we are saying it clearly establishes that the principles of equity and estoppel apply to this case, which entitles our client to payment. And so, in conclusion, we will summarize the disputed works constituted variations within the meaning of the FIDIC contract. Those variations were authorized by the appellant's engineer, Mr. Barry Paul, performed by the appellant's knowledge and approval. The respondent is therefore entitled to payment for those works. The Court of Appeal correctly identified and rectify the errors of the trial judge, and its judgment is both reasoned and just. And we invite this court to dismiss the appeal with costs to the respondent.
Right, well, thank you very much. Mr. Ramrogan.
My Lords, with your leave, my lady junior, Miss Temple May, will be doing the reply for the appellant. Thank you.
My Lords asked if there was a clause in this agreement equivalent to the one in the Gordon Winter case, and I can start by clarifying matters there. This FIDIC contract didn't contain that clause. That clause appears in the FIDIC Red Book, which is a remeasurement form of contract. So that's a contract where the employer, as opposed to the contractor, is responsible for the design. And the amount to be paid for the work carried out is based on remeasurement of work after it's been carried out. This contract here is a Yellow Book contract, which is a lump sum design and build contract. The Yellow Book is used where the contractor designs the project, And to protect the employer against the risk that that entails, it's a lump sum structure. So that explains why the 12.3 clause in Gordon Winter doesn't appear in this contract. And the answer to the board's question about that is no, there isn't a clause in this contract that says if a sum can't be agreed, then the contractor is entitled.
Well, there isn't exactly that clause, but there does seem to be a clause in the particular conditions which deals with the valuation of variations.
Yes, there's a process for valuing variations, but there isn't the fallback 12.3 saying if nothing can be agreed, then it's entitlement to a reasonable sum. And that's in the 1999 form. In fact, disputes around that have led to amendments to the 2017 form of the Yellow Book contract, but we're not concerned with the later form of that contract. With that context in mind, I can now address my learned friend's submission effectively that the express term that this is a lump sum contract doesn't actually represent the reality. Well, first of all, the point that I just made, this is a FIDIC Yellow Book contract, and the whole point of that form of contract is that the allocation of risk is such that the lump sum protects the employer against the risk that arises from the contractor being responsible for the project design. And the choice of a lump sum Yellow Book contract in this case, as opposed to a Red Book contract or another form of contract that allocates risk differently, is indicative that it was everyone's intention that it would in fact be a lump sum contract. And that's set out very clearly in the documents. Clause P4 of the preamble is the most explicit moment where that's set out at page 279 of the bundle. But also, if my lords look at the actual tenders that were submitted by the contractor in this case, the package 1 tender is at page 661. And you can see there that right under the blank where the contractor has written their, or right above the blank where the contractor has written their price, it says for the fixed lump sum of, and then fill in the blank. And it's the same for the package 2 tender, which is at page 670 for the fixed lump sum of. And it would be unusual in our submission if a contractor tendered in those terms but didn't actually mean it. The fact that the contractor would bear responsibility for things such as the finalization of the project design and examination of the site was also apparent from the start. At page 118 of the bundle,
Sorry, page?
118, 118,
Yes.
now this is from the instructions to bidders, paragraphs 8.1 to 8.3, and I won't read them out at length, but effectively the tenderer is advised to visit and inspect the site and surrounding areas where the works are to be constructed, and the tenderer is deemed to have satisfied himself as to the nature of the ground and the subsoil, the form and nature of the site, the quantities and nature of the work and materials necessary for the completion of the works, and in general to have obtained all necessary information as to the risk, contingencies, and other circumstances which may influence or affect his tender, and accept all risks associated with the subsoil, the form, and the nature of the site, etc. It's clear that, well, the next paragraph provides that tenders are going to be granted permission by the employer to enter the site for the purposes of making those inspections and assessments. And the point is that it isn't the case that this contractor was limited to the 2 site visits, the 2 structured site visits for which we have minutes. The contractor could have, at any time they wanted, gone, been given access to the site, carried out assessments and inspections, and satisfied themselves with the things that are set out here. And that was clear to anyone who was going to bid on this project.
But if it's, who owns the land? Is all the land owned by the authority? I mean, they would have to have the permission of the authority, because it was described as a sort of a roadway through a remote area.
Yes, well, if it's a roadway through a remote area, then they can, presumably, they don't need any permission.
Well, that's what I was wondering.
to go on the site and can carry out inspections.
And you say that that 8.1 would incorporate a change from having to put the pipe under the verge to having to put it under the roadway, under the asphalt.
Well, that's actually catered for even more specifically in the terms to do with the contractor satisfying themselves about the final design. There are clear terms that the design initially given by the employer is a preliminary design, and the final design is a matter for the contractor.
Where do we see that? Is there a provision?
Yes, there is. If you bear with me one moment, I'll find it. Well, there's subclause 1.1.6.13 of the particular terms.
Page.
It's in the bundle at page 240. That's the contractor shall be responsible for preparing and taking full responsibility for his own preliminary design and final design.
That's an addition to the standard contracts.
That's part of the, I think, the particular terms of contracts which are included by choice into the. There's the general terms, and then those are in places either added to or amended by the particular terms, and that was one of the particular terms that was selected in this case. And then I know that there is also a provision to the effect that the initial drawing is indicative. I might come back to that one.
That was in the instructions, wasn't it?
Yes, that's in the instructions to bidder. That's 136 is the pipe routes are indicative.
I'm grateful. That's what I was thinking of. The pipe routes are indicative. So it's made clear at the outset to the contractor that whatever routes, and we don't know what they were because we don't have the drawings, whatever routes were proposed initially by the employer were indicative only, and it was up to the contractor to decide, as the party responsible for design in this contract, where they were actually going to go. And so that's something that we say the contractor should have worked out before bidding. And there's no clear evidence about why it only came to be after the contract tender was submitted that the design changed in that way. So if this is a lump sum contract, which in our submission it plainly is, that leads to the case of Sharp and San Paulo Railway. It's right, that's a fairly old case, but it's particularly apposite to these facts. And the version of this case that's in the bundle is not particularly legible. I hope that your lordships received a copy of this case this morning that's easier to read.
We did.
I'm grateful. If I could take your lordships to that, please. The relevant part is right at the beginning of the judgment of Lord Justice James. In this case, the contractors undertook to make the railway, not to do certain works, but they undertook to complete the whole line with everything that was requisite for the purpose of completion, from the beginning to the end. And this is page 8 of the PDF, I'm grateful. They undertook to do it for a lump sum, something short of 2 million sterling, which was the amount upon which the Brazilian government had undertaken to guarantee the interest. Now, moving now to the beginning of the next paragraph, the first contract was that the line should be completed for a fixed sum. But the plaintiffs say that they are, upon several heads, entitled to a great deal more than that sum. The first head is that the earthworks were insufficiently calculated, and that the engineer had made out that the earthworks were 2 million and odd cubic yards, whereas they turned out to be 4 million and odd cubic yards. But that is precisely the thing which they took the chance of. they were to judge for themselves. There was no suggestion of fraud or willful miscalculation. And then at the end of that page and over to the next, the plaintiffs say it's quite clear that this was a miscalculation, but that was a thing the contractors ought to have looked at for themselves. So we submit that the circumstances are the same here. The contractor had obligations to consider what might arise in this project, what contingencies there might be, what problems they might encounter, and make allowance for that in their tender because it was a lump sum tender, and they were only ever going to be able to recover what they quoted within that. So that's the effect, we say, of this being a lump sum contract. The contractor had obligations. They can't now say, well, the pipe, in fact, had to be laid in the road, and that led to all of these other problems, and now we're owed just shy of an additional 14 million. Yes, of course. So, but the last sentence of that paragraph is one of the things which in my mind was clearly intended to be governed by the contract, was the company virtually saying whether the earthwork is more, whether it's less, that's the sum we are to pay. And so that's effectively what the authority is saying here. Even if you did end up having to excavate more than you told us you would, ultimately we only have to pay you what you quoted. My learned friend submits that the appellant's preliminary designs were for the pipe to be in the verge and that the contractor relied on those. Well, it wasn't for the contractor to rely on their designs. But in response to that also, can I dig into the evidence about this a little bit? There's no clear evidence. It's fairly unsatisfactory what led to the decision to lay the pipe in the road and who took that decision and why. And all of the witnesses who gave evidence were unsatisfactorily vague about this. And I'll give, my lords, the references. Milton Kwashi, the first of the witnesses, this is at page 68, and it's paragraph 16 and 17 of his evidence. Effectively, he says, when he commenced work, he observed that the employees were cutting into the roadway, even though he had thought that they were going to be the pipes were meant to be laid in the verge. So he can't tell us why that happened. He turned up to work, and that's what they were doing. Andre Johnson, page 76, paragraph 17 to 19, he said the plan was to lay and install the pipe at the side of the road, but that, quote, we discovered we could not continue to lay and install the pipe at the side of the road, and there were discussions between the claimant and defendant's representative, after which Barry Paul instructed us that the pipes would be placed in the roadway. So it's not clear why that was supposedly not possible, who brought that to whose attention, when that became apparent, what those discussions were. And Barry Paul said, and this is page 81, paragraph 13, when work on package 1 commenced, it came to my knowledge that it was necessary for the asphaltic roadway to be cut. But he doesn't say how. In relation to package 2, page 84, paragraph 24, he says, it was necessary to once again cut the asphaltic roadway, but doesn't say why. Naja Romain, page 88, paragraph 8, said, I was aware that works were being varied at various times, as there were problems with where the pipe was to be installed on site, but doesn't say what those problems were or who decided to solve them in that particular way. And then Raymond Thomas, page 98 to 99, paragraphs 31 to 33, only addresses this issue in respect of package 2 and not package 1. And he says, as we proceeded to perform package 2 as per the design and lay the pipe, I realized that it was no longer possible to continue the pipeline at the side of the road. But again, he doesn't say why or why that wasn't apparent earlier. So we just don't know what the origin of this decision was and whose decision it was. And this vagueness in the evidence is important because, as Mr. Ramlogad was submitting earlier, this is a key decision. It had a considerable impact on the rest of the project. Because it was undocumented, it's unclear how the variation came about and whether it was by a process equivalent to engineer instruction and contractor agreement, or, as seems possibly more likely, contractual proposal followed by engineer approval. There's just no explanation. And that highlights the importance of the procedure in this case, because it can't have been the party's intention for there to be a change of process, apparently impacting on the project so considerably, leading to considerable additional costs without proper documentation setting out whose idea it was, why it hadn't been appreciated earlier, and what impact it was going to have on cost. And the procedural provisions in the contract are intended to avoid a situation where these sorts of decisions happen ad hoc, orally, informally on site, and can't later be audited by somebody.
But what is the difference between an engineer instruction variation and a contractor proposal? I mean, it can't be just that the contractor stands by the side of the road and says, oh dear, and then the engineer says, well, you'd better put it under the roadway, as opposed to the contractor saying, we need to put this under the roadway, is that all right? I mean, it can't be manipulable.
Well, there are two ways. Clause 13.1 identifies two ways that variations can be initiated, either by an instruction or by a request from the contractor to submit a proposal. So either the engineer instructs the contractor to do something different, or the contractor comes to the engineer with a proposal and says, I propose to do something different. And those are the two ways you can end up with a variation. Both of them are required to be evidenced in writing. But they can either originate from the engineer or they can originate from the contractor.
So it is then just a matter of who actually says first, this needs to be done.
Well, yes, the contractor's proposal provisions are in more detail at clause 13.2, which is value engineering. So that's effectively where the contractor comes up with an idea that will actually help the employer and then submits a written proposal saying, we think this will help, we think this will be beneficial for X, Y, Z reasons, and here's our proposal. So
I think what's envisaged, presumably, is either that would happen or otherwise the only time you get a variation is if the employer, through the engineer, tells the contractor, well, you may have you may have conducted your design on the basis you're going to be doing X, but I'm telling you you've got to do Y. And then you're going to have to do something different from what you planned. And
yes.
then there's going to be, then you expect to get paid for that, fair enough.
Yeah, but we don't know, it's not clear from the evidence what happened in this case and whose idea it was. And everyone's actually quite careful, it seems, in their evidence not to say where that came from. There's a lot of use of the passive voice. There's a lot of it became apparent to me, I became aware of.
Right, now you've got a couple more minutes. So if you want
Yes. Can I raise quickly, or deal quickly with the point raised about this really being an issue between the engineer and the employer? Well, our primary case on that is that the engineers acted outside of the authority in any event in adopting this informal procedure. But further than that, the contractor can't sit back and become complicit with the engineer in non-compliance and then later send in a bill for a self-assessed amount. And as to the specific options open to the contractor, they can either insist on the procedure, so insist that their instructions are reduced to writing, insist on a procedure for determination under clause 3.5, communicate if necessary with the employer and say, look, the engineer isn't going about this in the right way, proceed under clause 3.6 of the particular terms, which is where they can make a proposal. Page 418 is where that clause is. Or they can make a claim for additional payment under clause 20.1. So there are a number of avenues for them open to them, and it's not, in my submission, open to them to take advantage of the situation and then later seek to check their own homework and submit a bill saying, well, this is how much all of this cost. Whoops, we didn't comply with the procedure. Now, my learned friend submits that WASA were complicit in the failure to comply, but in our submission, the evidence simply doesn't come close to establishing that. The respondent can't rely on general assertions like that updates were provided, or there were discussions, or there were meetings. this leads into the point about waiver and estoppel, and my lords have a primary argument on this, which is that it's too late now to raise that issue. But in any event, there would need to be some clear and unequivocal act on the part of WASA. And it's without doubt that there's no evidence of overt assurances from WASA that all of these variations in prices are agreed, notwithstanding failure to comply with procedures. So the respondent are forced to rely on what they say is the appellant's complicity in or acquiescence to that non-compliance. And they rely there on the appellant's failure to call evidence from Mr. Boyce or Mr. Nannen, who may have been able to speak on WASA's behalf. Firstly, we were instructed that by the time this claim was brought, they weren't in the employ of WASA. But in any event, there is a primary burden of proof on the respondent to establish what exactly they say that the appellant were told or were aware of. We accept that in the right circumstances, a failure to object to a state of affairs might be unequivocal enough to amount to a waiver or give rise to an estoppel, but only if there's good evidence in the first instance that the person who failed to object knew what they were failing to object to. And before meaning can be attributed to WASA's failure to object, the respondent has to establish what they were aware of, and they haven't met that burden of proof, and that's a preliminary burden of proof that lies on them. They say that WASA were kept informed, but there was no specific evidence of what they were told, when they were told about each of these variations, whether they were told that they were variations, when that was communicated, whether they were told that they would sound in additional claims for payment, and whether they were made aware of the informal process that had been adopted between the contractor and the engineer on site. And without all that information, in our submission, it's impossible to assign the meaning to the appellant's failure to object that my learned friend seeks to assign. What specifically did they fail to object to?
Right, so we got your point on waiver. Is there anything else you wish to add?
No, that's the last point that I want to make, and unless I can assist with anything further, those are our submissions in reply.
Thank you very much. Well, we're very grateful for counsel for their submissions in this case and for all those who assisted them in preparing it. The board will take time to consider their judgment, and we will notify the parties when there's a judgment ready for promulgation. Thank you.